Hello, this is Darlene J. Clark with another episode of Child Abuse Awareness. Be a part of the solution instead of part of the problem. I not only share my story, but of other stories, what are happening to our children, what are happening to other people that should not be happening. Please like, follow, and subscribe. Get to the banners here. At the bottom, I'm showing right now trigger warnings, trigger warnings, trigger warnings. Be sure you pay attention to that. Let's start with Matthew 18, verse 6. But whoso shall offend one of these little ones which believe in me, it were better for him that a millstone were hanged about his neck, and that he were drowned in the depths of the sea. And in Matthew 18, verse 10, take heed that you despise not one of these little ones, for I say unto you, that in heaven their angels do always behold the face of my Father which is in heaven. For a lot of my friends, I like this Colossians 3:21. Fathers, do not embitter your children, or they will become discouraged. There's a copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or commercial use tips the balance in favor of fair use. So I'm going to go over it, share with Dennis Allen Gaal, Gaal, 49-year-old pedophile, arrested for attempted child rape and attempted child solicitation. This will be it. Hello, Jackie. I'm doing pretty good. Good to see you. How are you doing? This story will be hard to take, hard to accept, but we do have to get the word out there. We're not going to stand and idly by and just watch this stuff happen. We will speak out about it. What is it? Wait till I'm recording or something for a phone call to happen. It's a pharmacy, but I don't have anything prescribed there, so it's like, okay, you know. So, anyway, without further ado, I'll go ahead and present this story. Oh, you got a message that before we go into that, do you want us to talk about your update? You'll WhatsApp me later on? Okay. Well, that's cool. You won't believe this pedophile right here. Look at him, y'all. He is absolutely disgusting. I can't wait. Raping a baby who was 10 months old was part of a Mississippi man's birthday trip to Tennessee, affidavit says. This was Tuesday, December the 12th, when he got arrested. 5:38 a.m. Central Standard Time is when this was written. Okay. Warning. The details of this story, um, I need to go ahead and put on the bottom of this. Let me put trigger warning. Let me run that across the bottom of the screen too. Go back over here to this. I'll make sure that that stays on there. The details of this story are graphic and disturbing. Chattanooga, Tennessee, a Mississippi man who thought he was making a birthday trip to rape a baby in a Tennessee hotel room is now behind bars, according to police documents. Chattanooga State Police arrested 49-year-old Dennis Allen Gaal on Thursday. On Tuesday, sorry. On Tuesday. Yes, very triggering. An affidavit obtained by WTVC noted Gaal communicated with an undercover agent from the Federal Bureau of Investigation on the Telegram app on November 17th. There is a sorry excuse for a human being. People like this, I think they need the death penalty. When you'll find out in a little while why I say that, okay? You'll find out in a little while. Because even if you're going like that, remove their penises, that's not going to help. Because I know I got an ex-boyfriend who got arrested after I left him for messing with two girls, and he could not use his because of health reasons. But he still broke into the homes and messed with girls. He still did it, even though his manhood no longer worked. He still found ways. As long as he got arms, he could still do that. Why should we have to front them when they Dow identified himself as a contract chef for an offshore hiring company and said his age of attraction is ages 0 to age 12. See, he admits that he's attracted to newborns too, look. But they can be older than that if they look younger. So they can be older than 12, but they have to look like they're at least 0 to 12 years old. Gall said he felt the Telegram app was secure and that he was hesitant to join other groups for fear of being caught. The agent mentioned the possibility of sexual contact with a 10-month-old boy. Very unbelievable, isn't it? Would it hurt the baby? But we'll love to play sexually. We'll love to see if it happens. Will be a dream come true, Gall replied, according to the affidavit. Well, he done did this dream too many other times, too. A dream come true, excuse me? Okay. The agent told Allen he was from Tennessee, to which he replied, looks like I may have to take a trip to Tennessee sometime soon. They exchanged phone numbers, and Gall soon started texting the number to set up an encounter. That allowed agents to look up his phone number, which revealed Gall's name and that he had previously been convicted of molesting a child he babysat in 2000. See, he previously done this. Gall stated that there were 3 boys he molested. 3 other ones prior to this. Do you see this? So he continues. See what I'm saying? Between the ages of 2 and 4, the affidavit said. Gall stated that he molested the boys all while awake most of the time. The report noted Gall said it all started with his 2-year-old nephew, adding that he said he molested the boy for 3 years. Exactly. Well, the people had to be aware of maths, minor attraction. Exactly. And what's scary is that an infant, somebody would be sexually attracted to infants also. And I already know that that's true because my sister even said that what daddy did to me when I was an infant. And then I know of other friends that happened to them when they were infants. And here's another sicko right here. On November the 20th, Gaal asked the agent what part of Tennessee they were in. Upon hearing Chattanooga, the report says Gaal replied, "That sounds awesome. Awesome. I can't wait. This is looking to be the best trip I've ever taken." Yes, he knew exactly what he was doing. December 5th, Allen sent the agent. Yeah, he knew exactly what he was doing. Sickening, ain't it? Gaul then booked 2 rooms at the Hotel Chalet, formerly the Chattanooga Choo Choo, sending the agent a screenshot of the booking information. The report said on December the 5th, Allen sent the agent an image of 5 infant outfits along with an elephant rattle. So he actually bought gifts for the infant also. Allen showed up at the hotel on Monday, which was his 49th birthday. Their agents arrested and booked him. Gaal was charged with attempted child rape and 2 counts of attempted solicitation of a minor. Okay, so now we got that in note. So let's go to this other little tidbit of information here that we found. And as I said, fair use. Okay, let me warn y'all, it is going to be trigger warning. As I said at the bottom, this is very triggering. State versus Gaal in 2001. So think about how old he was in 2001 when it's 2023 and it was his 49th birthday. Okay? So, Court of Appeal of Louisiana, Fifth Circuit. So, this was in Louisiana that this happened. See? October the 17th, 2001. Panel composed of Judges Edward A. Jefferson Jr., Susan N. Chihardy, and Walter J. Rothschild. Okay. Paul D. Connick Jr., District Attorney, Tarita A. Cancel, Terry M. Bordeaux, Appellate Counsel, Joseph A. Louis, Trial Counsel, Gretna, L.A., Counsel of the State of Louisiana, Plaintiff Appellee, Leroy Hartley, New Orleans, L.A., Counsel for Dennis A. Gaal, Defendant Appellant. Oh yeah, he is. He's a professional groomer by the sound of it. Oh yeah, for sure. He's a sicko. On June the 29th, 1999, so that's even lesser than that. That's in 1999, right? The defendant, Dennis Gaal, was charged in a 2 count bill of information with 1 count of sexual battery upon a juvenile in violation of LSA RS 1443.1 and 1 count of aggravated oral sexual battery upon a juvenile. So he actually sexual kissing type of stuff, oral. I don't have to go there. I don't have to explain. Y'all know. He was arraigned on December the 27th, 1999, and pled not guilty. On January the 6th, 2000, the defendant filed various pretrial motions, including a motion to suppress statements and or confessions and a motion to suppress evidence. He was wanting to suppress the evidence. Boy, I would have thought something really bad if they did that, if they allowed him to suppress the evidence. On August 14, 2000, the state filed two motions in Lamine. One of these motions sought to exclude reference to criminal charges brought in another parish against this defendant for alleged sexual abuse of this victim. The second motion sought to exclude reference to an alleged act of child abuse by this victim's uncle against another child. Okay? But that's the uncle. We're just going to bear basically on him. On April the 4th, 2000, a hearing was held on the motions to suppress statements and evidence. After hearing testimony, the trial court ruled that the audio tape and transcription of the defendant's statement to police was admissible. The trial court heard additional testimony and thereafter ruled that the audio tape of the defendant's threatened suicide was admissible. Finally, the trial court heard testimony concerning the videotaped interview of the victim. I guess he wanted to kill himself if they was going to go and do all the evidence, right? He was threatening suicide, but he ain't never done it, did he? Instead, he keeps going on these heinous acts and harming these kids. The trial judge ruled that the state had proven the authenticity of the videotape, but he reserved ruling on its admissibility until he viewed the tape and had a hearing on the competency of the victim. On July the 20th, 2000, a hearing was held to determine the competency of the victim. The victim testified and was examined by the state, the defendant, and the trial judge. Prior to the trial court's determination, the defendant sought to admit into evidence the transcript of another competency hearing in another state court involving this victim, and the trial judge denied the request. Thereafter, the trial judge found that the victim was competent to testify at trial. The trial judge also viewed the videotaped interview of the victim and found it to be admissible. Of the victim, put in mind the victim. Trial was conducted on August 14th through the 16th, 2000. On the first day of trial, the state and the defendant presented arguments concerning the state's two motions in Lamine. The trial court granted both motions. At the conclusion of the trial, a six-person jury found the defendant guilty as charged on both counts. On October 5th, 2000, the defendant was sentenced to serve 5 years of imprisonment at hard labor without the benefit of the parole. Just 5 years. That's all he got was 5 years for what he did to this kid and these other kids. To that kid, I guess. Probation or suspension of sentence on count 1 and 5 years of imprisonment at hard labor without the benefit of parole. Probation or suspension on the sentence on count 2. The sentences were ordered to run consecutively, and he was given credit for time served. No, don't give him any credit. Make him start all over. Whoa. Therefore, the trial judge heard and denied the defendant's motion for a new trial. That same day, the defendant filed a motion for appeal, and it was granted by the trial court. And here's the facts. Are you ready for the facts, Jackie? At the trial of this case, the state called DP. That's who they call the boy. DP's mother, Anita White, Officer McGregor, Emily Gordon, and Dr. Scott Benson to testify. Dawn, who is the mother of DP, testified that she was engaged to Gary Miller and that she first moved in with him when her son was 2 years old. 6 months later, a friend, Dennis Gaal, came to live with them in Chalmette. I don't know how y'all pronounce this. Chalmette or Chalmette? Yes, just 5 years is all he was given. And now look what he's done. He's still trying to meet up with kids. The three adults and a child lived together at that location for 7 to 8 months, at which time Gary, Don, and DP moved away. In May 1998, Gary, Don, and DP moved into an apartment in Kenner. They remained at that location until April 99. Don testified that during this time, Gaal visited frequently, often babysat DP, and frequently spent the night on the sofa at their apartment. Anita White testified that she was a friend of Dennis Gaal. She stated that she and her husband had attended school with him and knew him by the name Spanky. According to Miss White, in April 1999, Gaal told her that he had something to tell her and that she would not like what he had to disclose. Miss White inquired whether Gaal had killed anyone, and he told her no. She next asked if he raped anyone. Miss White testified that Gaal responded, "That depends on your definition of rape." See that? That's his response. That depends on your definition of rape. Miss White told Gaal that she did not care to hear what he had to say. Later that evening, Gaal disclosed to her that he was gay and that he had sex with someone who was very young. That is not sex, that's rape. That is not sex. A kid cannot choose. Exactly, they keep getting away with it. Miss White was aware that he had lived with Gary and Don, so she asked if it was DP. According to Miss White, Gaal admitted having had sex with DP, and he told her that he would kill himself before he would go to jail. What do you think what you did to the kid? You had sex, you raped him repeatedly for 3 years? Miss White told Gaal to tell the child's mother because she would tell her if he did. The defendant went to Don and Gary and told them that DP had been making sexual advances towards him and that at the age of 2 years, DP had asked Gaal to sexually fondle him. What? He's trying to ask the child. He's blaming the child. Look. Told them that DP had been making sexual advances towards the adult. You see that? And had asked Gaal to sexually fondle him? Excuse me? A kid don't ask for that. Look at that. The child had asked him to fondle, had asked the grown man to fondle him. Wow. The next day, Gaal called Mrs. White, told her that he had told Don of their encounter and that she was going to get help for DP. Gaal's revelation shocked Don and she confronted her son, DP, about the allegations. According to Don, she asked of her son if he had touched Gaal's dingling, which is a word used by the child's penis. DP responded, "No, Mama, he's been doing it to me." See that? "No, Mama, he's been doing it to me." Know how to get around the law. My friend says they're always sorry when they're in the dock. Exactly. Sickening, ain't it? Like I said, this is trigger warning because it's explicit here. When asked to explain, DP said he put his dingling in my mouth. And it made me put my dingling in his mouth and he peed on me. Whoa. The child told his mother that this happened in the bedroom when she went to get Gary from work. People, this goes to show, be careful who you leave your kids with. That's what we keep saying. Approximately 2 weeks following Gaal's revelation to Mrs. White, Don and Miss White were together socially at Gary's mother's house. Don mentioned that Gaal had told her that DP was making sexual advances toward him, and Gaal felt that someone was molesting the child. At that point, Miss White realized that Gaal had not told Don what he had told her, and she revealed to Don what Gaal had previously told her. Don and Gary decided to call a family meeting with Mrs. White present so that Mrs. White could confront Gaal with his prior disclosure to her. That's why I said this sorry piece of crap deserves a death penalty. He deserves a death penalty. You know, he's continuing trying to do this. What other kids is out there that he's getting away with at his location, you know? What other kids is he around that people just don't know? And he could even be in a men's bathroom when he has to go to the bathroom in a restaurant or something. Wow. On April 14th, 1999, the family meeting was called with Gary, Don, Anita White, and her husband Jody, and Alan Miller, and Dennis Gaal in attendance. During the meeting, Mrs. White relayed that she had been told by Gaal. Ms. White testified that Gaal shook his head and kept saying, I guess I'm guilty. I guess I'm guilty? He kept saying, I guess I'm guilty? That is not really an admission right there. I guess I'm guilty. You wanted to blame the child and say he came on to you? Gaal then told the group that he was a victim and that he did nothing wrong. Wow. Wow. He was the victim of a tiny kid and he couldn't do nothing about it, but he was the victim. Don't believe your son. He's not the victim. I'm the victim, he says. He told the gathering that he had awakened to find DP naked in his bed, and a child told him he's putting it in the hole. What? What? Upon question, Guy admitted that he allowed DP to perform oral sex on him. Guy was told to admit himself into a hospital or the police will be called. Trigger warning, everybody. I'm just, it keeps saying at the bottom. On April the 16th, 1999, Don called the Kenner Police. Detective Brian McGregor, a detective with the Kenner Police Juvenile Division, proceeded to the residence in Kenner. The reason why we're going over this, even though this is 1999, this was the dude that showed up in Chattanooga, Tennessee in December to meet up what he thought was a 10-month-old baby to do some things to him. So, yes, this takes precedence. This is important. Detective McGregor testified that he first spoke with Don alone when DP was playing in another room, and he learned that DP had disclosed that he was sexually abused by Spanky. Don gave the officer the specifics of the allegations as she knew them. Thereafter, DP was independently interviewed. He told the policeman that Spanky put his ding-a-ling in his mouth and peed on him. Officer McGregor then arranged for the child to be interviewed by a forensic interviewer with the Child Advocacy Center. Yep, narcissistic creep. He does not want to be found out that he's guilty. He wants to blame the child. I've seen other people say, well, you got if a child, the teenager comes on to the grown man, it's a teenager's fault. No, and you're the one doing all this. And if a teenage girl or a teenage boy or anything like that came on to an adult person, You're an adult. You say no. You know, you don't just go along with it. Excuse me. Don't get. Why are you attracted to them? Why do you let it happen? That won't happen if you're a respectful person. You will not let it happen. I don't care if somebody come on to you or whatever. You're a grown up. This is a child. Officer McGregor testified that on April 27, 1999, he drove Don and DP to the Child Advocacy Center. But we all know that that guy's the one that did it. The boy didn't. But I'm sick of these perverts that actually go and say, well, the child came on to me. That's utter BS. They always want to blame the victim. Well, the victim wanted it. Different stupid, crazy crap like that. The child was brought in by his mother. Once the child was comfortable, Don left the interview room. Only the interviewer and DP were in the room at the time of the interview. The child's permission was sought to videotape the interview, and he agreed. Officer McGregor listened on a monitoring device outside the examination room. Drawings were used by the child to clarify the information given. The information given in an interview was consistent with the information given at the time of the police report. On May 20th, 1999, a forensic pediatrician examined DP. The child told him that he was there to talk about Spanky. During the history given by DP, he said that the perpetrator put his penis in the victim's mouth and licked the victim's penis. DP also said that Spanky peed on me and sucked my dingling. The child indicated the dingling was his penis by pointing to his private area. DP stated that Spanky put his dingling in DP's mouth and shook it. Finally, the child told the doctor that Spanky put his finger in the child's rectum. Oh my gosh. Oh my gosh. Wow. Cultures of the child's mouth, throat, and rectum were taken, and the results are negative. No bruises, tears, or redness was found, and the physical exam was consistent with the history. The physical exam was consistent with the history, though. In explaining these findings, the doctor said that he saw the child sometime after the assault, and thus he was not surprised that the physical findings were normal. The defendant presented testimony of Lewis Maynard, who is the defendant's godmother, his parents Linnell and Martin Gaal, and Carol Ewing, who is the victim's paternal grandmother. The defendant also testified in his own defense. Brave, brave boys. Going against this monster in court? Brave. Yeah, they do. They don't want to go to jail, so they want to say, oh, it's all them. Carol Ewing relayed a story at trial about how she found the victim acting out sexually one day when he was in her care. Mrs. Ewing had left DP playing with his two young cousins, and when she returned to check on them, she found DP with his pants down. She asked him what he was doing, and he said he was trying to get his cousin to lick his penis. He said that the dog Shorty does this. According to Miss Ewing, on a second occasion she saw DP expose himself to his cousin and she corrected him. The witness admitted that the incidences occurred after the abuse involving the defendant. Under cross-examination, Mrs. Ewing admitted that DP had told her that Spanky hurt him and peed on him. The child told her the defendant put his finger in the child's behind. DP also told Miss Ewing that he cried and asked the defendant to stop, and he would not, and that the defendant brought him a toy. What they do, they try to buy him to shut you up. They buy him a toy or something. Lewis Maynard testified during the trial about a conversation she overheard between Don and Don's mother while she was shopping in Kmart. According to Miss Maynard, Don was overheard telling her mother that they were not going to charge Gaul in St. Bernard, but she thought that they would charge him in Jefferson Parish. Mrs. Maynard also said that Dawn stated to her mother that she did not want to hurt the defendant, but she had to cooperate or she would lose her child. She didn't want to prosecute him? What the heck? She did not want to hurt the defendant, but she had to cooperate so she wouldn't lose her child? Wow. Isn't your child more important than that stupid pedophile? Wow. Had to cooperate or you'll lose your child. I don't think you need your child anyway. You didn't want to do it. You didn't want to protect him. Are there other people in your life that you're going to let around him and ain't going to tell her nothing like that because, now these people know this, so I'm being threatened and I ain't going to do nothing about it. But if I don't do something, then they'll take my child away, But I don't want to do nothing to him. I don't want to hurt defend him. I don't want to hurt him. What about what he did to your child? Do what? What about what he did to your child? Whew. Martin Gaul, the defendant's father, testified that the victim, his mother, and Gary had visited Mr. Gaul's home with the defendant on several occasions. On two occasions, Martin Gaul testified that he had found DP naked in the hallway early in the morning. According to Martin Gaul, he told the child to go tell his mother to put his clothes on. Wow. So evidently, he had hurried him up probably outside of his room where he was naked after an attack. The defendant testified that he began living with Gary Miller before 1997. Don and DP moved in with them in January 97 when DP was 2.5 years old. He babysat the child on numerous occasions and occasionally bought toys for him. Gaul stated that when DP was 2.5 years old, Gaul was giving the child a bath, and according to the defendant, the child asked Gaul to search his penis. He does not. Hello there. How are you doing? We get mad about this, Tammy. So he's still saying that when he gave the 2.5-year-old child a bath, that boy asked him to touch his penis. You don't do that. You got to wash them, but that's different. Bathing is different than doing that. Hello there, our bucket list host. Wow. Gal said he refused and asked DP if anyone had ever done that. Gal said the child told him yes, his pawpaw Tony. Gal therefore asked the child's mother what was the name of DP's pawpaw, and she gave another name. He did not tell DP's mother about the incident that allegedly occurred during the child's bath. Of course not, because you're lying. You're lying. Gal testified that 3 nights after this incident, he awoke to find DP playing with Gal's genitals. He stated that he ran the child away, but again he did not tell the child's mother. According to the defendant, he held all this information inside and it caused him to have a nervous breakdown, lose his job, and return to live with his parents. The defendant testified that in April of 98, he spent 5 nights with Don and Gary and he slept on the sofa. One night, DP came in and was naked, so Gaul asked him what he was doing. According to Gaul, the child replied that he was putting my dinghy in the hole. Gaul said that he ran the child away again, but he never told anyone about the incident. Gaul stated that this same series of events occurred 3 more times between DP and himself, once when Gaul was staying nearby at Gary's brother's house, once on the night before Thanksgiving, and once around January 99. Each time the defendant's response was to run the child away but not to tell his mother. Wow. The defendant said he was emotionally distraught and thereafter he refused to babysit DP. According to Gaal, he confessed to Anita White that he was gay and that he awoke to find DP in his bed fondling Gaal's genitals. Gaal said Miss White told him to tell the child's mother because if he didn't, she would. I do way worse than people think the law really not doing much. Yeah, all he had to pay for doing this to this kid was just 5 years. That's all. God testified that he went to Gary and told him that he had awakened to find DP fondling Gal's genitals. According to Gal, he also told Gary that the child had told him that his Papa Tony taught him this. Gal said that he told Gary about the 4 times that he awoke to find the child naked and in his bed. The child's mother later informed Gal that the child had accused Gal of sexual abuse. So the child is coming and telling everybody that Gal did it, right? And Gal is the one who said, "Oh, it never happened. Nothing never happened." Yeah, it's sickening because he paid. He reason this is 1999. The reason why I'm going over this same pedophile did not know he was talking to an FBI agent, and so in December of this year, 2023, he met up with. He thought it was just a regular guy with a 10-month-old baby boy, so that he could bond and do something sexual to him in Chattanooga, Tennessee, for his birthday. So then I'm going back to the back case of him doing this. Like, why did they do something then? And now he's still in the processes of meeting up, trying to do this for kids. How many kids has he done this to, and the people just let him do it? It's sickening. The gal testified that on April 14, 1999, he was summoned to Don's house for a family meeting. Once there, Anita White told him that she could not believe that Gaal had called her a liar. Don said that she wanted to hear Gaal's side of the story, and he told Don what he had told Gary. Mrs. White responded that Gaal had not told them the same thing that he told her. See, he changed his story, okay? The average, like kids. Yeah, it is. It's very crazy. So then Gaal testified that after this incident, he felt that he had lost all of his friends and he contemplated suicide. He took an overdose of medicine and made a farewell tape, and then he admitted himself to Charity Hospital. No, he said he did not want to go to jail, so he would kill himself so he didn't have to go to jail before he would be arrested and go to jail. That's what he had claimed. So get the story straight. Man, how many lies are you going to tell? Long discussion. Although he did not designate it as a specific assignment of error, the defendant argues in his brief that the evidence presented was insufficient to convict him of the charged offenses. Oh, since the evidence was, since he looked normal, so I should just get away with doing it? Y'all just gonna let me go ahead? Please let me go away because there's not enough evidence on him physically, since it's an old thing. He asserts that the state failed to establish by direct evidence any criminal conduct between himself and the alleged victim. Well, guess what? You came clean and you told Tammy, I mean, that white lady, Mrs. White, you told her. You confessed to her. She told her to just go and tell the people that you done this with a kid. And if you don't, I will. But she goes and says, she tells the parents, he came on to me. She Gal went and told the parents. He came on to me. State argues that the essential elements of each offense was proven beyond a reasonable doubt. When issues are raised on appeal as to the sufficiency of the evidence, and as one or more trial and errors, the review in court will first determine the sufficiency of the evidence. There's where the note thing is. In order to determine whether the evidence is sufficient to sustain a guilty verdict, an appellate court must decide whether, viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found that the state proved the essential elements of the crime beyond a reasonable doubt. And there's some more stuff about Jackson versus Virginia and so on and so on. A determination of the weight of the evidence is a question of fact resting solely with the trier of fact who may accept or reject it in whole or in part. The testimony of any witness, State versus Silman. A reviewing court may impinge on the fact-finding function of a jury only to the extent necessary to assure that the defendant have received due process of law. It is not the function of appellate court to reweigh the evidence or assess credibility. In this case, Dennis Gaal was charged in count one with sexual battery upon a juvenile by touching the genitals of the juvenile. The crime of sexual battery is defined in pertinent part as follows. Sexual battery is the intentional engaging in any of the following acts with another person who is not the spouse of the offender, where the offender acts without the consent of the victim, or where the other person has not yet attained 15 years of age and is at least 3 years younger than the offender. And you remember, Jackie, they were actually saying something like, I had sex with somebody that's a lot younger. I'm gay and I had sex with somebody a lot younger. Was a victim coming here? Exactly. Number one, the touching of the anus or genitals of the victim by the offender using any part of the body of the offender, or the touching of the anus or genitals of the offender by the victim using any part of the body of the victim. Okay, here's count two. Count two of the bill of information, the defendant was charged with aggravated oral sexual battery by placing the juvenile's penis in his mouth and or placing his penis in the juvenile's mouth. The crime of aggravated oral sexual battery is defined in pertinent part as follows. And as we stated earlier, that the guy, when he agreed to meet up with that guy in Chattanooga, Tennessee, December this year, 2023, that he said that his age that he's attracted to is from age 0 to age 12, and said they could be older than 12, but they have to look younger. Yeah, he's guilty. Aggravated oral sexual battery is an oral sexual battery committed when the intentional touching of the genitals or anus of another person and the mouth or tongue of another is deemed to be without the lawful consent of the victim because it is committed under any or more of the following circumstances. Number four, when the victim is under the age of 12, which he was, lack of knowledge of the victim's age should not be a defense. You tell him. That's right. And he knew the ages because he was living there with them. At the time, he said he was 2.5 years old when he moved in there. At the time of the offenses, the victim was 3, 4 years old and the defendant was 23, 24 years old. No, he said that when he moved in, that's when he started, the boy was wanting him to touch him. So I believe that he was even touched even before the 3, 4 years old when he's 2.5 years old. Because he said he gave him baths, remember? And he said the boy begged him to let her play with his pee-pee. At the time of trial, it's dingling as they call it, the time of the trial of this matter, the victim was 6 years old and the defendant was 25. The victim testified that the defendant touched his private with the defendant's finger and ejaculate on the child's private. Oh my gosh. Ah. Oh my. Trigger warnings for sure. Whoa. The child also testified that the defendant put his mouth on the child's private. The victim's mother testified that after her initial discovery of alleged abuse, she asked the child about it and it was told that the defendant had put his penis in the child's mouth. The child was made to put his penis in the defendant's mouth and the defendant ejaculated on him. Anita White testified that Gaal admitted to her that he had sex with DP. He actually said he had sex. He also admitted to her that he allowed the victim to perform oral sex on him. Allowed him? Allowed him? Whoa. Allowed him. Whew. Officer McGregor, you forced him. This is a child. Officer McGregor testified that the child told him that the defendant put his penis in the child's mouth and ejaculated on him. The forensic interviewer testified that the victim told her the defendant put his finger into the child's rectum. The physician testified at trial that the child told him that the defendant put his penis in the child's mouth and licked the child's penis. The child also told the doctor that Gaal sucked his penis and ejaculated on him. Finally, DP told the doctor that the defendant put his finger in the child's rectum. Ooh. The defendant denied sexually assaulting the victim and he continued to allege that the victim made sexual advances towards him. See, he's still denying it. He's still blaming the child. 20-something years old, and he's blaming the child. This 2, 3-year-old child was doing this to me. I didn't do nothing sexual to the kid. I didn't do nothing to the kid. Well, we know that there's 3 that he had been arrested for. There's got to be others. And then he did the wrong thing of trying to meet up with an FBI agent. He used Telegram. He thought Telegram was secure and he would not get caught on doing it on Telegram. Well, he was looking forward to doing something with a 10-month-old boy. That was his plan. He said he's attracted to 0 to 12-year-olds. It is clear from a review of the record that the jury, when faced with conflict in the evidence presented by the state and the defendant, chose to believe the testimony of the victim and other state witnesses regarding the sexual abuse of DP, and to disbelieve the defendant's testimony denying the abuse. This is a credibility determination that will not be disturbed on appeal. I bet there is too. I bet there is as well. Viewing the evidence in the light most favorable to the state, it is clear the state proved the essential elements of the crime of sexual battery pursuant to LSARS beyond a reasonable doubt. Moreover, viewing the evidence in the light most favorable to the state, the record demonstrates that the state proved the essential elements of the crime of aggravated oral sexual battery pursuant to that beyond a reasonable doubt. How many other kids are, these women are hearing that their child come on to him and they're believing this predator? How many is out there believing in what? This is crazy. Yeah, he claimed that he's gay. That didn't give him no right to do whatever he's doing. He told Miss White that he had a gay relationship and he had sex with somebody much younger. And then she told him, go tell the parents, of the person. And then he went and told the parents that, oh, your son came on to me. He did these things to me. He wanted me to play with his stuff and all that kind of stuff. And they never even said what he had claimed. He would never dare tell the parents what he claimed to that other person. In his first designated assignment of error, the defendant argues that the trial court erred in finding the victim competent to testify because he could not respond to some questions. He was unable to distinguish between right and wrong, and he was unable to discern the difference between what he saw and what was told to him. The state alleges the testimony presented supports the trial court's finding of competency. Okay, so now this court discussed the issue of competency within the context of child sexual abuse. Okay, so the law regarding the competency of a witness is quite clear. Every person of proper understanding is competent to be a witness except as otherwise provided by legislation. Understanding and not age is a test of whether any person shall be sworn as a witness. A key determination to be made is whether the witness is able to understand the difference between truth and falsehoods. The determination of the trial court that a child is competent to testify as a witness is based not only upon the child's answers to questions, testing his or her understanding, but also upon the child's overall demeanor of on the witness stand. And in State versus Foy, Louisiana Supreme Court noted that a child's hesitation or unresponsive answers do not necessarily indicate incompetence, but rather may be a part of an overall demeanor in an unfamiliar courtroom situation that favorably reflects testimony only as to what is clear to the child. Plus, a child's embarrassed. A child's afraid. A child's frightened. A trial court's determination on the competency of a child to testify is entitled to great weight on appeal because the trial court judge has the crucial advantage of seeing and hearing the child. State versus Troilette, I go through there. The trial court judge is vested with wide discretion in determining the competency of the child witness and ruling his ruling would not be disturbed on appeal, absent on abuse of discretion. So at the competency hearing, the victim, DP, who was 6 years old at the time, was called to testify. Put in mind, this happened since he was 2.5 and up. Upon questioning by the trial court judge, DP stated that he attends church and believes in God, and he promised to tell the truth. He gave the name of the school he attends and stated that he had just finished kindergarten and he was in the first grade. When questioned about what subjects he took in school, he did not understand. Of course, because they don't have different subjects like that. He just goes to school, they don't have it split up like math and English and all that, like when you're in kindergarten and first grade. However, he answered correctly when he was provided with specific examples. When asked what it meant to tell a lie, DP responded that it was to tell a different story. DP further stated that your mom and dad punish you when you tell a lie. He said he was not afraid of God if he lied, that he was not afraid of God if he lied, but he was afraid of his mom and dad. The child admitted that he does get into trouble at times. What kid don't get into trouble, right? Under question by the state, DP was given hypothetical. I can't even say the words right now. I'm still tongue tied. Hypothetical question situations and asked to tell whether they could constitute a lie. He did so correctly. He stated that he was to tell the truth when he was sitting in the witness chair. Under examination by defense counsel, the child stated that he would tell the truth. He said he had told lies in the way past. He stated that they uh, were 8 days to a month. DP did not understand when asked the difference between what you know and what someone tells you, but when he was presented with specific examples, he was able to correctly discern the difference. Upon final question by the state, the victim responded that he would tell the truth. Okay. The record reveals the victim knew the difference between the truth and a lie. Moreover, when presented with concrete examples, the victim was able to differentiate between what he knew and what he was told. Finally, although there was one incorrect response given by the child regarding the number of days in a month, and two questions he did not understand, it is clear from the record that these questions were initially presented in a manner that could not be comprehended by a 6-year-old child. This is illustrated by the fact that once the questions were presented in concrete terms, the child understood and responded correctly. I don't even think my grandson that's in a first grade knows how many months is in how many days are in a month. Sometimes there's 28, sometimes there's 29, sometimes there's 30, sometimes there's 31. Considering the record before us, particularly the testimony of the child, we find that the trial judge did not abuse his discretion when he found the child victim competent to testify. Accordingly, the defendant's first assignment of error is without merit. In the second assignment of error, defendant alleges that the trial judge erred in refusing to admit into evidence a copy of a competency hearing occurring 10 months earlier, in which the victim had been found incompetent to testify. The defendant appears to argue that this prior finding supports his current position that the child was not competent to testify. At the conclusion of the competency hearing in this case, the defendant attempted to offer the transcript of the St. Bernard competency hearing. After the state objected, the trial judge found the transcript of the St. Bernard hearing to be inadmissible. He stated that the child's competency at another time was not at issue and that he had the opportunity to test the competency of the witness at the time of trial. Boy, he's really trying to get out of it, ain't it? Like, don't listen to the child. Exactly. In denying the admissibility of this transcript, the trial judge apparently concluded that it was irrelevant and not probative of the child's current state of competency. Well, I'm getting ahead of myself. This has really got me all fired up. I'm sorry. Considering the fact that a competency hearing was held before the trial judge in this case, and that the child's competency at the time of this trial was at issue, we cannot say that the trial judge erred in excluding the transcript of the St. Bernard hearing. Accordingly, this assignment of error is without merit. So when we go, the defendant's third, fourth, and fifth assignments of error are related and will be addressed simultaneously. In this third assignment of error, the defendant contends that the trial court erred in granting the state's motion in Levine to exclude any evidence concerning those allegations with respect to the prosecution of the defendant of the 34th Judicial District Court for the parish of St. Bernard on August 14, 2000. In his fourth assignment of error, the defendant argues that the trial court erred in granting the state's motion Levine to exclude any reference to abuse allegations involving Anthony Miller. In his fifth assignment of error, the defendant asserts that the trial court erred in its ruling that the state's motion in Levine to exclude any references to the hearing held on September 20th, 1999, in the matter of the docket in the 34th Judicial District Court, wherein the alleged victim DP could not answer the questions presented to him by the court to determine DP's competency, thus depriving the defendant of his right to call witnesses to show that DP had likely been coached since his testimony at that hearing. I don't think he should be questioned by this pedophile. The defendant contends that the trial court's rulings on the motions in Levine deprived him of a fair trial. He alleges that these rulings prevented him from presenting evidence and calling witnesses in his defense, as well as effectively cross-examining the state's witnesses. The state responds that the defendant had a fair trial at which he was actively represented, and the trial court correctly granted the motions in Levine as the evidence the defendant sought to present was irrelevant. No witnesses were presented at the hearing on the motions in Levine. The motion in Lamine concerned the St. Bernard proceedings indicates that this defendant was charged with aggravated oral sexual battery and indecent behavior with a juvenile in May of 1999. At least one alleged victim was DP. The prosecution was voluntarily dismissed on October 26, 1999. In the motion, the state contends that the evidence is irrelevant to this prosecution and therefore inadmissible. The motion in Lamine concerning Anthony Miller indicates that Miller, who is DP's uncle, had been investigated for child abuse, and the allegation was found to be false. The trial court first took up arguments on the motion concerning St. Bernard proceedings. The state argued the matter was not relevant to this proceeding, which is true. Defense counsel responded that he thought the evidence was relevant and that his client sat in jail for 7 months on charges that he abused DP and that the charges were voluntarily dismissed. In granting the state's motion in Lamine on this issue, the trial court made the following ruling. All right, the court not having been presented with any law one way or other on this, neither in the state's motion in Lamine nor in the defense position that this information should come in, the court is going to rule that it's not admissible. The police action of the district attorney's office in another parish is not relevant to this prosecution, and I'm going to so rule. But let's go on past the Anthony trial court, then took up state's second motion, Lamine, concerning Anthony Miller, because they're irrelevant to the fact in this case. The state pointed out the court that the uncle was accused of the abuse of another child, a female victim, and the allegations against him were investigated by child service and found to be false. The defendant argued that the evidence was admissible because it would explain the family's motive in pursuing him and secreting the fact that a member of the family had been accused of child molestation. So now he's actually trying to. Hello there. Hope you're doing good. Yeah, I'm pretty good. It's really getting to me, if you know what I mean. It's really triggering to me. So, but I'm trying to bear with it. Thanks for caring and asking. It's really hit me hard. And granted the state's motion in Lamine to exclude evidence regarding alleged sexual abuse by Anthony Miller against another victim, the trial court stated the following reasons. I'm not going to let an investigation of a non-defendant, non-victim in this case, an investigation that went nowhere as far as the district attorney's information, an investigation of an alleged abuse of a female enter into these proceedings. So you see what he was trying to do? He was trying to actually blame the other guy. He tried to first blame the little boy, the kid who he abused. Now he's trying to blame this other Anthony Miller. On appeal, the defendant does not contend that the face of the trial court's ruling on the motions in Lamine were incorrect. Rather, he alleges that the results that flowed from those rulings had deprived him of the right to a fair trial. More particularly, the defendant contends that he was not able to let the jury hear two tape statements he made, one given to the police in St. Bernard and the other a suicide tape, both of which allegedly contained exculpatory evidence. Specifically, the defendant alleges that by listening to the tapes, the jury would have been able to hear his denials of the abuse of his victims in his own words, which I'm sure they got to hear, because he's still right here denying it. So what's it matter? You're an adult. He's a child. The kid did not do this to himself. The kid did not ejaculate it all over his mouth. You did it. You're the adult that ejaculated in the kid's mouth. Sorry, piece of crap. Additionally, the police tape would have provided the jury with information that the victim allegedly told the defendant that his pawpaw, Tony, was the abuser and that this allegation would have been supported by the fact that Anthony Miller had been investigated for abuse of a young female. Finally, the defendant argues that the rulings prevented him from calling parties to the St. Bernard proceedings to show that DP had recently been found incompetent to testify. Well, he's trying every which way to not be have to pay for what he done. In the present case, the defendant timely objected to the trial court ruling that the evidence was not relevant. However, on appeal, he asserts that he has been denied a fair trial, which is completely different from the grounds specified at trial. Since the defendant presents this ground for objection for the first time on appeal, the trial court was not afforded the opportunity uh, to rule on it. To preserve the right to seek appellate review of an alleged trial court error, a party must state an objection contemporaneously with the occurrence of the alleged error, as well as the grounds for that objection. There's no grounds. This is all just hearsay. There's no proof. We had discussed a similar situation that with State versus West. Initially, it is noteworthy that defense counsel only objected to the complaint of testimony at trial as being hearsay and irrelevant. There were no contemporaneous objection made on the grounds that the statements were highly inflammatory in nature. Thus, the provisions of LAC, which require a contemporaneously objection and the grounds therefore to preserve appellate review of a trial error, were not satisfied. We have held that the grounds of counsel's objections must be sufficiently brought to the attention of the trial judge to allow him the opportunity to make the proper ruling and correct any claimed prejudice to the defendant. Therefore, a new ground for objection cannot be presented for the first time on appeal. It is settled that a new basis for an objection cannot be substituted on appeal, that only the grounds made known to the trial judge at the time of the ruling may be relied on by this court. Thus, his argument is untimely and not properly before us for review. There are some citations omitted that was, so we'll go on further down, so further this, okay. But said, in this case, St. Bernard proceedings involved the same defendant, the same victim. However, the defendant failed to establish how those proceedings related to the material issue in this case. The evidence of the victim's prior accusations against the defendant could have been relevant and admissible to impeach the credibility of the victim if the defendant had established that the victim made prior false statements of sexual abuse. However, no such showing was made in this case. The fact that the defendant was accused of sexual abuse and then the state entered a nolo prosequi to the charges as argued by the defendant to the hearing of the motion. See, the weird thing is, the boy only said to his parents and to others that this guy, Gaal, is the one that did it, okay? But according to Gaal, he wants to blame that the grandfather did it. He wants to say that the grandfather. Of course, then he wants to blame the child. Then he wants to blame this other person. He wants to keep blaming everybody. Moreover, except himself. Moreover, the defendant has not shown that the St. Bernard proceedings were relevant to the issue of the victim's competency. As previously discussed in assignment of error number 2, the best test of a person's competency is a person's current ability to understand. This is a determination for the judge as a preliminary consideration and not one for the jury. Oh, so you know what? He's actually mad because the boy can now testify. He didn't want the boy to be able to testify against him. And we're going to get past that because that's not even, he's just trying to throw that name in there so that he can blame that person too. That Anthony Miller. For the reasons set forth above, we find the defendant's third, fourth, and fifth assignments of error are without merit. In the sixth and final assessment of error, the defendants assert that the trial court erred in allowing the introduction of the videotape of the interview conducted by the forensic examiner at the Children's Advocacy Center on April 16th. Excuse me. He contends that its prejudicial effect outweighed its probative value. He further asserts that the trial court erred when he ruled that the requirements had been met. The defendant first complains that the state is preparing the videotape did not comply with the statutory safeguards for recording statements of juvenile sex abuse victims. In particular, he alleges that the recording did not take place pursuant to a court order and the child was unduly influenced by the interviewer. Oh, now he's blaming the interviewer. See right there that the child was unduly influenced by the interviewer? Boy, he's blaming everybody, isn't he? The state counters that the interview was in accord with the statutory guidelines. The defendant also argues that the videotape was inadmissible because its prejudicial effect outweighed its probative value. The state replies the videotape was properly admitted into evidence by the trial court. Wow, then he, see right here, he filed a motion to suppress evidence in which he sought to have the videotaped interview of the victim suppressed. At the motion hearing, Officer McGregor testified regarding the procedure utilized in making the videotape. The trial court gave the following reasons for finding the videotape had been properly authenticated. While satisfied that again the preliminaries were taken care of properly, that the tape was handled in the proper manner, and the interview of the child took place in a proper manner. So I think that we're talking about really makes sense. I'll deny the motion to suppress it as it relates to the preliminary matters in advance of the taking of the tape. Well, he tried everything, suppress evidence, everything. Wow. After the hearing, at which the trial judge found the victim competent to testify, the judge viewed the videotape and finding the videotape to be admissible into evidence, the trial court gave these additional reasons. Having reviewed the tape, the court is of the opinion that its potential judicial effect is outweighed by its probative value. The court finds the child was not improperly influenced in its answers to the question, and that I'm going to rule that the prosecution can use the tape naturally with cross-examination of the witness by the defendant available. The following events occurred when the videotape was offered into evidence by the state of trial. Judge at the point, I'll offer file introducing the evidence, state 1 and 3 of the videotape of the drawings. So see, the boy had drawings too. I'm going to go further down, going further down here, skipping along here. And, okay, so here's the error patent discussion. The record was reviewed for errors patent when patent error was noted. Okay. At the time of sentencing, the trial judge ordered both sentences to be served without benefits of parole, probation, or suspension of sentence. However, the commitment does not mention this restriction. In the event of a conflict between the commitment and the sentence, the transcript controls. State versus Lynch, 441, whatever. The absence of a statement in the commitment indicating that the sentence is to be served without benefits is a clerical error that does not prejudice defendant's rights. State versus Gilmore. Therefore, we remand to the trial court to amend the commitment to specify this restriction. For the reasons set forth above, we affirm the defendant's conviction and sentence and remand to the trial court to amend the commitment to conform with the transcript. Affirm remanded with restrictions. And they said, in order to protect his identity, the victim will be referred to as DP in accordance with that statute. Only the first name of the victim's mother is used to protect the child's identity. The transcript indicates that Anthony Miller is Gary Miller's brother. That's who he had lived, you know, Gary Miller is who Gail had lived with. It is noted that during the trial, the court ruled that the defendant could testify as the statements he made on the audio tape. The defendant, however, withdrew that line of questioning when the state cautioned that the questions would open the door to evidence which was prejudicial to the defendant. Oh, so he didn't want to be caught even more, right? So he wouldn't ask questions. These type of people cannot be real, but exactly. That's why I went ahead and told him, I said, his best bet is, just some people said cut her sweetie ding off or stuff like that. I said, that's not going to help because I got an ex boyfriend who's in jail now. I found out about him being a pedophile and all that kind of stuff. And I went ahead and I told on him and stuff. And this is horrid. It's horrible. And even though he could not even use his manhood anymore, the ex boyfriend still broke into two young girls' places where they lived and still was caught sexually abusing them. So it does not matter. You could cut off his penis, cut off balls, stuff like that. They'll still use something to harm a child. They got to get their jollies off some way. They'll use whatever. Their hands, anything. These people are sick, disgusting. They let this guy out. How many other victims are there? He now supposedly lives in Mississippi. That when he did this case, this was in Louisiana. So, but when he was caught recently, he was in Mississippi, and he was traveling to Chattanooga to meet up with the 10-month-old boy to do something sexual to him. Even took pictures of clothing that he bought for the newborn, for the infant, and even an elephant rattle. So he even sent pictures of the 5 different. Yeah, exactly. Castration does not help either. I like that Bible verse that shows. Let me go to that Bible verse right quick. Um, let me go to it right quick. I really like this. But whoso shall offend one of these little ones which believe in me, it were better for him that a millstone were hanged about his neck, that he were drowned in the depths of the sea. You know what I'm saying right there? I really believe that that's what he's done, unfortunately. Especially when it's got these perpetrators like this. Very sick and it's very disgusting. Why do we want to keep paying for these people to keep harming our kids? Why are we letting them back into society? Why are we putting more of a problem for these kids who don't deserve this? We are just supposed to protect our children. I watched another video on the TikTok before I come on to this one, and there was this girl who this boy just kept snapping her bra, and she went to the teacher and she told the teacher, she said, he won't stop doing this. He said, just ignore it. Of course, it was a male teacher. Said, just ignore it. Well, he kept snapping, and then it made her bra come undone. So that she lost her cool because nobody was protecting her. So she ended up hitting him and bloodied his nose or something. The school ended up calling the mom, telling her to come. She could not answer her phone because she worked in the hospital in the ER, right? Or ICU or ER somewhere. So she could not leave. She was doing her job, sewing somebody up with stitches and things. And they told her, so we've been waiting so many minutes, like 45 minutes or something. We're having to wait on you. Why ain't you? You need to remand your daughter. Okay, what did he do? Well, he was, she backhanded him. But why did she end up doing that to him? Uh, because he did that, but they said it's okay. She still should not have hit him. She's like, oh, instead of y'all worried about y'all getting a sex offense against this little boy that's doing these sex acts towards my daughter, messing with her private area where her bra will come off. Excuse me, and y'all are saying that she's the one that needs discipline. So she ended up contacting the school board, and the school board was going to handle this. Thank you so much. And we've got to get this out there. I am going to try to see if I can show y'all his picture again. Okay, before we go, I want to show you this perpetrator yet again. All right, present. Let me get the share screen. Show you his picture. See, he actually said, "I can't wait to get this out there. I can't wait raping the baby." His documents like this, he was actually saying himself as a contract ship for offshore hiring company and said his age of attraction is 0 to 12. So that's the age of attraction. See, he mentioned the agent mentioned the possibility of sexual contact with a 10-month old boy, and he said wouldn't hurt the baby, but would love to play sexually. Would love to see if it happens. Will be a dream come true. He actually had that written in there, y'all. And so this was actually showing y'all the date here, right here. So this was actually in this paper, December 12th, 2023. So that's recent. Same perpetrator, sicko. So exactly. That's why I went ahead and showed the other information. What I did, of the prior cases. That's why I went ahead and did because this showed later on what this guy is up to still today. You know what I'm saying? This guy that done these things to that boy that the case that I done it. So I said, well, looking back what he did, this is what they did. And he's trying to say that, oh, he didn't do this, he didn't do that. Well, guess what? He actually, the person that he ended up making a deal with, he didn't know was an FBI agent. Could you say busted? But I bet he's just going to get a hand slap on the wrist, y'all. Because as that said, that, I gotta look up his name again, Dennis Allen Gaal. I get because all he got accused of, all that he got charged with, is let me get it right here. You want to make it bigger so I can show y'all again what his present screen. All he got charged with was attempted. So here here it is. Until on Monday, which was his 49th birthday, agents arrested him, and Bucktown Gal was charged with attempted child rape and 2 counts of attempted solicitation of a minor. So he actually showed up at the in Chattanooga. And look at what he actually said right here, too. Looky here. He said, on number 20th, Gaal asked the agent what part of Tennessee they were in. Upon hearing Chattanooga, the report says Gaal replied, that sounds awesome. I can't wait. This is looking like to be the best trip I've ever taken. Like, what the heck? So I really felt like this was very necessary on getting this out there because this perpetrator's still out there, y'all. He is still out there. And as far as I know, he's in Chattanooga, Tennessee right now since he's been convicted. I hope that they not give him, um, I don't know when his case is going to be. And they said that was 7 days ago. So it's like, what is going on? So he was actually, that's just 6 days ago that he was, boy. So we need to make sure to keep up with that. Wow. Let's see right here. I just found something else out. Hold on. Hold on. I just found y'all something. Hey, let me show you this right here. Let me show y'all this, okay? I hope he's got time. Okay, here's his entire screen. There we go. Allow. Can y'all see the screen yet? Here he is, right here. Dennis Allen Gaal. See, there's where his last known address was. Aggravated oral sexual battery. Any other offense committed in another jurisdiction, which would be considered one of the offenses in section in Mississippi. Wow. See, there's other offenses also. They convicted sexual battery. August the 16th, 2000. Wow. Let's see right here. Nah. Wants me to end up going to that site and paying. I ain't gonna do that. Wow. I don't know what the latest is. All I know is, that this has been a couple of days. And so y'all help keep it on top of it and keep the word out there because this guy is still, no matter what, um, out there. Let's hope that they didn't just let him go with paying paying a fine or whatever. Let's hope he gets the maximum since he's got so many cases. Did y'all see in there how that just kept happening? All the times about all the arrests right there. They convicted August 16, 2000. And that's in Mississippi, though. And the other ones that we talked about earlier, remember it was in Louisiana, right? Aggravated offense be considered one of the offenses. Yep. See, sex offender It's the last known address. Boy, and these poor kids. Y'all, let's not just keep saying apologizing to the people and saying we're sorry. Yes, he does. He moves around a lot. That's what's so scary about it, man. What's so scary? Boy, I hope some other people will end up doing this story too, because it needs out there. This is sicko for him to even be aroused at a newborn. A newborn. You go and shop in a grocery store and you think the innocence and people just admire your little newborn, right? Then you know that these pedophiles like this sicko that really even likes newborn babies for their sexual pleasure. Sickos. These type of people don't need to be around in our world. They don't need to be walking among us. They don't deserve it. They don't deserve the same air we breathe or nothing. So disgusting and foul. If they can't protect our kids, and yeah, we can't be a vigilante or nothing like that. What? I mean, I think God's got the simplest thing right there, by saying it's better a millstone be tied around the neck and thrown in death to the sea than it is to harm one of these little ones. Come on now. Why don't y'all go by God's standards? Why are you letting these perpetrators continue to harm our kids? So vile. They shouldn't have even any rights. You're worried about, that they get medical care and all this other kind of stuff. What about the things how they torment a child and how it's going to mess with them the rest of their lives? It's never going to go away. It's going to be there. All right. Well, thank y'all so much. And say God bless y'all. And thanks for coming and supporting. And have a blessed day.